Hello class, this is our first actual video lesson. I'm picking up where we left off on Chapter 10, Criminal Law and Criminal Procedure. We have just a little bit left to cover, which primarily deals with cybercrime. But before we get to that cybercrime, which will be the next video, in this video I want to review the important concepts that we've covered so far. So we begin with the difference between civil and criminal law, focus mostly on the fact that criminal law has different participants. It's the government versus the accused rather than two individuals or two businesses. And the burden of proof is on the prosecution to prove beyond a reasonable doubt that the defendant committed the crime. Also, there's a difference between substantive criminal law and procedural criminal law. In substantive criminal law, we are talking about the actual crimes and the defenses. In procedural criminal law, we're dealing with the process that one goes through from the time a crime is committed to the arrest all the way through trial and then possible appeal. Keep in mind that with regard to substantive criminal law, today all crimes are statutory. There are no common law crimes. The classification of crimes is into felonies, misdemeanors, and petty offenses. Felonies, of course, are the most serious, and you can receive incarceration of a year or more for those, as well as the death penalty. For misdemeanors, it's jail time of less than a year, and for petty offenses, it's generally a fine. Okay, at common law there were two elements required for most crimes: the actus reus, which is the act, and the mens rea, which is the intent. Today, because criminal violations are statutory, most statutes contain within them the intent element. So it might be something like recklessly or without regard to safety, whatever it might be, would be the intent. There are some crimes that are strict liability crimes that do not have an intent element. Those are limited, and they're usually for public safety purposes. Okay? We said that the failure to act can be a crime when the accused has a duty to do something and did not perform that duty. And that duty usually comes from a statute. Inchoate crimes or incomplete crimes, basically there we're talking about conspiracy. Conspiracy is defined as an agreement between two or more persons to commit a crime where one of those conspirators takes an overt act towards the crime. The crime is not necessarily completed, and all parties can be guilty of the conspiracy. The other inchoate crimes are basically the intent crimes, like intent to commit murder or intent to rape or something of that nature. We talked a little bit about organized crime. The main thing to remember is the RICO statute, which is a federal law. States have also enacted RICO statutes. Basically, they use laundering as a method to get after organized crime, but there's a lot more to it than that. Also, RICO statutes have a civil component to them. Then we talked about defenses. I'm not going to go into each defense and what they mean. You should know that from the previous lectures and from your book. They include self-defense, justification, necessity, insanity, mistake, duress, entrapment, immunity, and statute of limitations. Now, make sure you differentiate between the insanity defense, which is a defense to a crime, and if successful, basically is like an acquittal, except that the person will go to a mental health facility until they are no longer mentally ill and dangerous to others. Compare that with, or contrast that with, what we call incompetent to stand trial, which is where the defendant is not able to understand the proceedings and not able to assist their attorney and therefore cannot get a fair trial. In that situation, the person is found incompetent to stand trial. They're sent for treatment. When their treatment results in their being able to understand the proceedings and help their attorney, then they're brought back to court to have their trial. Okay, so criminal procedure was the next area we covered. We talked about criminal procedure basically being developed in the 1960s and thereafter by the U.S. Supreme Court. The Supreme Court looked at many of the Bill of Rights and started applying them in the context of criminal law. The Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment are the primary ones. The Fourth Amendment dealing with search, seizure, and arrest. The Fifth Amendment dealing with the right to remain silent and not incriminate oneself. The Sixth Amendment dealing with the right to jury trial, etc. And the Eighth Amendment dealing with cruel and unusual punishment. None of these rights would have any meaning but for what's known as the exclusionary rule. This is the rule that was adopted by the Supreme Court that says that when any of these rights are violated, the evidence that was gathered in violation of those rights has to be excluded at trial. That is a very important doctrine that leads to the protections that the court wanted to apply with regard to these amendments. Now, in addition to that, there's an offshoot from the exclusionary rule called the fruit of the poisonous tree. And that means that not only does the court exclude evidence that was wrongfully obtained, but any evidence that was obtained as a result of that wrongfully obtained evidence will also be excluded by the court. An additional law or rule made by the Supreme Court is the Miranda rights. And basically what the court said is that all these constitutional rights that we supposedly have are not very useful if we don't know about them. And so therefore they put the onus on police to warn people of these rights, such as the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be appointed for you. So those are the Miranda rights that have to be given to accused individuals in order to protect them. And so then we talked about under the Fourth Amendment searches and seizures, and we said that the key point was that you cannot have a search and a seizure or an arrest without probable cause. Probable cause is sort of an amorphous doctrine. We're not going to get into it any more than just to mention that it's not easily definable, though the courts have done so. And we did talk about exceptions to all these rules, searches and seizures and arrests. For example, with regard to arrests, a police officer can arrest somebody without a warrant if the crime was committed in front of the police officer. With regard to searches and seizures, we talked about the exigent circumstances exception, which allows police to search and seize in situations that are caused by an emergency. So then we get to the end and the process that's involved, starting with the arrest of the accused, and then the arrest has to be followed by, or is sometimes before actually, indictment, which is the charging of the person with a crime by a grand jury. Grand juries usually consist of about 23 people. They vote, and it's a majority vote, not a unanimous one, and they simply have to find probable cause to believe that a crime was committed and that the defendant committed the crime. And then they issue a true bill, which is an indictment, or if they don't believe that the standard was met, then they issue a no bill. In some instances, the DA or the prosecutor can go forward without an indictment using what's called information, which is simply a sworn document. Following indictment, the accused goes to the court or to the magistrate for arraignment, where they are told what the charges are against them, and they have to enter a formal plea. They can enter a plea of guilty, not guilty, or nolo contendere, and we talked about all those. At this time also begins the process of plea bargaining, where the district attorney or the prosecutor enters into negotiation with the defendant to try and enter a plea. The prosecution benefits by getting a sure conviction and by saving court time and expense. The defendant benefits by getting a lesser